when did you use meth?
I haven't used meth. I've been around people. I've been using it. I stay with a girl. She's pregnant, and I showed her repeatedly.
So here's the thing.
Okay.
You're typically not going to test positive just for being in the same area.
Yeah.
Hold on. Okay. If you're that close to somebody using it, then you know better.
Yes.
And there's already an issue because you're here for a sentencing in clause number 25 DCCR 1393.
Mm-hmm.
And you've already have been on probations, felony probations that have been revoked. And in addition, you deny that you even knew what was going on the day. And so you denied the offense. And so for those reasons at this time, based on, I'm not necessarily saying I'm going to not accept the plea agreement, but what I am going to do is I'm going to raise your bond in your case today, and I'm going to raise it to $50,000.
Yes, ma'am.
We'll reset the case 2 weeks for sentencing. I'm not going to sentence someone if I think they're under the influence.
Yes, ma'am.
We've already got, I feel like, maybe not. Hold on. Can they do a substance abuse evaluation in custody?
Oh, yes, ma'am.
How long would that take?
We can get it done this week. Should be able to get it done this week.
All right, so I'll reset the case 2 weeks. We'll get a substance abuse evaluation taken care of, and then if there's any recommendations based on that, then we will get that taken care of.
Yes,
if
ma'am.
you make that $50,000 bond, a condition of it is that you have to wear a drug patch
Yes,
at all times.
Yes, ma'am.
I don't care who you're around, what you're doing. If it tests positive, I'm going to have to assume that it's because you're using.
Yes, ma'am.
So if you're living somewhere where people are using methamphetamine, you ought to not be living there.
Yes, ma'am.
Understood?
Yes, ma'am.
Go back with the bailiff. Are you Kevin Lee Tran?
Yes, yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictments and the motions?
He does, Judge.
Mr. Tran, in clause number 25 DCCR 0423, you're charged with the second-degree felony offense of assault on a peace officer from March 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
This was in there. And are you pleading guilty because you actually did what they charged you with? Sorry.
Yes.
And then in clause number 25 DCCR 0424, you're charged with the third-degree felony offense of assault on EMS personnel from March 14th of 2025. And how do you plead to that charge?
No contest.
It's that you're either guilty or not guilty. And are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? In those two cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Speak up, please.
Yes.
And Your Honor, I would ask the court to take judicial notice of the letter dated March 12, 2026. Should have thrown it in at the first.
In what case?
All of these cases, Your Honor.
Okay, hold on.
Mr. Tran had been evaluated, was incompetent for.
Oh, hold on. Okay. All right. I'm going to take judicial notice also in all of the court's files. And Mr. Tran was evaluated for competency and was found not competent to stand trial back in August of last year, was sent to the John Dunn Behavioral Science Center for competency restoration, received the report from them dated March 12th of 2026 that has the finding that Mr. Tran has attained competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
Not from the defense, Judge.
Not from the state, Your Honor.
Okay. Then at this time, based on that report, I will find that Mr. Tran is competent to stand trial. Okay. All right. So I went through clause number 0423 and 0424. And so, Mr. Tran, did you go over the paperwork on the tablet with Mr. Lewis?
Yes, Your Honor.
And you fully understand it?
Yes.
And you understand, if I follow the agreements that you've made with the district attorney, that you're waiving your right to appeal.
Yes, Your Honor.
State tenders number one in each case.
No objection, Judge.
They're admitted in each case. Again, I'm going to find that Mr. Tran is competent to stand trial. Mr. Tran, I'm going to find that you entered your pleas of guilty in each of these cases freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 25 DCCR 0423, find you guilty of assault on a peace officer, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 0424, find sufficient evidence to find you guilty, and at this time find you guilty of assault on EMS personnel, sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-37560, I have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the state jail felony offense of theft of property, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, Your Honor.
And Judge, count one is one of the offenses we just pled to. Count two is one that's being dismissed. We could just do count one of these. That's right with the court.
1 and 3.
Yes, Your Honor.
And then in cause number 21-38780, I also have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the 3rd-degree felony offense of assault family violence by impeding breath or circulation. And that was a 5-year term in prison that was probated for 5 years. Is that also correct?
Yes, Your Honor.
These cases each allege that you violated your probation. Count 1 in each case alleges that you committed the new offense of assault on an EMS personnel, the one that we just went through, from March 14th of 2025. And is that true or not true?
Yes, it's true.
And then count 3 in each case alleges that you committed the new offense of assault on a peace officer from March 14th of 2025, also the other case that we just went through. And is that true or not true?
Yes, Your Honor, it's true.
Did you enter your pleas of true in each of these cases to counts 1 and 3 freely and voluntarily?
Yes. Yes.
And did you plead true to those counts because those counts are actually true?
Yes.
In each of those cases, I also have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
Yes.
And do you fully understand them?
Yes, Your Honor.
And again, you understand, if I follow these agreements, that you'll be waiving or giving up any right to appeal.
Yes, Your Honor.
State tenders number 1 in each of these cases.
No objection, Judge.
It's admitted in each of those cases. All right, Mr. Tran, in each of these cases, in cause numbers 21-37560 and 21-38780, I'm going to find that you enter your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true. And 21-37560, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-38780, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in all 4 cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. I have just signed a dismissal in cause number 25 DCCR 0422 as part of that agreement as well. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your
This courtroom moment quickly turned serious when a defendant tested positive for methamphetamine and tried to deny using it, claiming it was only from being around others. The judge wasn't convinced, making it clear that being in that environment is already a bad decision. With a history of probation violations and dishonesty about the case, the judge raised the bond to $50,000 and delayed sentencing, ordering a full substance abuse evaluation. She warned him clearly, if he tests positive again, the court will assume he's using, no excuses. In another case, a defendant faced multiple serious charges, including assault on a police officer and EMS personnel. After previously being found incompetent, he was restored and pleaded guilty. But his situation worsened as his new crimes also violated past probation terms. The judge revoked his probation and handed down multiple prison sentences, all running together. Across both cases, the message was clear. Repeated mistakes, drug use, and ignoring court conditions will only lead to stricter punishment. In this courtroom, accountability isn't optional, and every decision carries real consequences.